Alderman across the room.
Smith, if I may, you had indicated that you represented Mr. Hood in his first trial in 1997. Is that correct, sir?
That is.
And then following a motion to new trial, a new trial was granted, and there was a second trial in 1999. Is that correct, sir?
There was a second trial. I'm totally unfamiliar with any of that trial.
But you remember that there was a second trial like you testified to on your rag. You just don't remember when it was.
I don't, no, I don't remember anything about that trial.
Sure.
Except, I think the public defender represented.
Sure. Your Honor, I have with the mark the State Exhibit number 1438. This is a certified copy of the case number issue 97 CR 0877, showing the verdict of guilty in December of 1997, the sentence, as well as the motion for new trial and the order granting the motion for new trial, as well as the second trial that was held, the verdict in that matter and the sentence in that matter.
Interjection.
I've seen 15, 20 years, Judge. Some people say me.
All right. There's no objection.
No, sir.
Submitted. Ma'am, bring that to you. I would tender that into evidence, Judge.
Submitted.
Mr. Smith, of course, as you know, the district attorney at that time was Harry George. Is that correct, sir?
Yes,
In 97 and 99, correct?
yes,
Okay. And you indicated that Danny Love was the assistant district attorney who handled the trial that you were involved in. Is that fair to say?
it's shown in the record. I had forgotten who the DA was.
Okay. And the judge at that time was, throughout that matter, was Steve Jones. Is that right?
That is correct.
And he's an African-American judge, correct?
Say again?
He's an African-American judge, correct?
Yes.
And he is, after serving as Superior Court judge here for a number of years, from 1995 in 2011, he was nominated, and his nomination was approved to be a federal judge. Isn't that correct, sir?
What's the relevance of what he was nominated? I kept what he done to me. He could be president. I ain't still won't stand there with it. So it just irrelevant as far as what his nomination, what he doing now.
How was it relevant?
Indicated about who the judge was, so I'm pointing out who the judge was. I think it is, though.
All over the objection.
Yeah, I saw he got reversed recently or something, so yeah, I mean, but he makes mistakes like everybody, even though he's a federal
Yeah, no,
judge
that's not a
now.
response to my question, and that was
But
right there. It's not a response to
I
my
will take,
question.
he can answer his question the way he wants to, like his witnesses, not me. If the judge want to see fit to do it, he can answer his question. After he finishes answering, he can make up yet to it.
I didn't even have a chance to finish the question I had.
I thought you were through.
Ask your question.
Thank you.
If you'll wait till he finishes his question, Mr. Smith, then you may answer.
Certainly, will you wiggle your finger at me so I know you're through?
He was nominated by the president, approved by the Senate, since he was sworn in as a federal judge for the federal district court for the Northern District of Georgia. Isn't that correct, sir?
Actually, I was not at the swearing in. I've heard and read in the newspaper, yes. And I saw him and had lunch with him recently, 2 years ago.
Well, you don't doubt he's a federal judge, do you?
No, I know he's a federal judge. I told you, he got reversed recently. I saw that.
And
And by the way, I've tried federal cases many, many times. Have you?
That's not responsive.
No,
I do.
no, I'm just,
I simply asked to be a federal judge, that's all I have.
the point is,
Your Honor,
I'd like-
just continue to go on, say whatever you want to
Let me
say.
deal with this objection.
That was not responsive to the question.
Yeah, Judge, he let him finish his answer before he make the objection. He make an objection before the man finish that?
I'm going to sustain the objection as non-responsive.
Now, it's fair to say in 1997, well, let me strike that. You've been a lawyer, you indicated, for 41 years. Is that right, sir?
1974, June 12th, I believe.
So in 1997, you've been an attorney for around 23 years. Is that correct, sir?
Whatever it is, yes.
And it's fair to say that, of course, as the defense attorney for Mr. Hood, you vigorously defended him. Is that right?
Of course.
And you
Except I
indicated-
made a mistake.
You indicated that you defended him on another case that you acquitted him of, that he was acquitted of, is that right?
That's correct.
What was he charged with there, sir?
I was just reminded, I think it was a rape charge, it was a bogus charge, whatever it was, because it got thrown out by the judge.
And in this particular matter, in December of '97 is when that trial occurred, is that right, sir?
It's whatever's shown on the transcript.
Show you what's been marked as State's Exhibit 1439.
What is that, 1439?
Yes.
What is it?
You recognize what that appears to be, the transcript from the trial that you represented on in December of 1997, sir?
That's what it appears to be.
It's about 500-something pages, is that right, sir?
Oh, no. A lot of pages. Here you go. It's 560-something pages. It's 563 pages.
Yes, I had that back.
May I see that back again, please, a moment?
Excuse me.
I want to review, you gave it to me to review, I want to look at one thing from it. Judge, may I?
Your Honor,
I am not through looking at it.
he's not the attorney. I have to ask.
You identified it, like,
Yes, sir.
question.
Thank you. And, sir, prior to that trial, you filed a motion to suppress identification testimony, did you not, sir?
If it's shown, I should have filed that. I would assume I did, because that was the whole case, misidentification. One witness, misidentification.
State's Exhibit 1440.
Well, I just confer with staff, my counsel, you need something to take outside for the interior right quick and bring them right back in, so if you want to knock out the way, so they're not bleeding.
That's all your numbers or? Yes, sir.
I just refer, staff, my counsel, I would like to make an objection that he just said something like that old charge I had to kidnap and rape whatever before. They threw it out. He been know about it. It ain't no secret. It's on the record. Been on the record since '97. And he just brought that up. I didn't bring it up. I didn't elicit it. He sua sponte said himself, and I didn't say that about it. If he was gonna bring it up, he's supposed to have done it the right way instead of just eliciting it out there, just to try to prejudice me. So I would move on this trial that issue. He already knows about it. He was trying to be nice and nasty about it. However, the charge was, he represented me, the judge threw it out. It was bogus. Me and the girl, we continued with our relationship. We was engaged to get married, but he lied on me and put me in prison. However, he knew what he was doing. I'm like, that's why it's kind of, some slime, but he been doing slime. He is a slime.
And that's not appropriate.
You know, in my book, I know it ain't appropriate, but I said he wanna do that. I mean, if he wanna do that, show us this video when you killed my brother. You wanna bring up something, let's walk the whole 9 to 10 yards. Let's don't walk them 2 or 3, let's walk the whole 10. He wanna be slime, let's get to it. So, this slime ball, okay.
I'm not gonna hear any more of your objection if you don't focus
Okay,
on that.
right, I apologize, Judge, I apologize. I apologize. I won't do it again. But for the record, he knew what he was doing. Judge, it's been on my record for years, it ain't no secret. The charges were dismissed, but he just brought it up at this moment in time. He could have been done. When he introduced the first time, he could have been the first base. There was a calculated move on this behalf, and his bias and praises, I seen the lady look at me like she was crazy. He should have been introduced. He know about it. So I just, for the record purpose, I move on this trial, bias and praises, sends the face, he wait to get this guy done, and I didn't even listen to him. But again, he did it to be, you know, unprofessional. So again, for the last time, he could have been brought this up, it's on the record, it'll never go nowhere. The charges were dismissed, but still him just gonna bring it up like that there. He knew what he was doing, and it was biased prejudice, because it misleading the jury. If he gonna say that, he need to explain to the jury why did the judge throw it out.
Small.
Judge, it's a matter that he brought up with the witness himself. That was his witness. And when he asked him about whether he represented him, the witness, who's an attorney, said, yes, I represented you on a matter in which you were acquitted. It was a matter that he brought up himself. And that came out through his witness, what he said at that time. It was, that's what that was.
That's what I recall as well.
But I don't recall saying that about the charge. He the one said, on suicide, say, yeah, we talked about it. I asked, have you represented before? Yeah, I represented you on the prior charge that we talked about earlier. James didn't say that. He suicide, he said it himself. I didn't elicit that. I didn't do it. He done it. I can't control how he answered. But I didn't sit there and say, did you represent me in this first charge and it was thrown out by the judge? I didn't do that. It was him. He did the suicide, the witness done it. James didn't do it.
All right. Motion for this trial is denied. Mr. Hood, do you request a curative instruction?
Yes, I really do. I'm going to show what we stand by on. They need to know that the judge dismissed it. The judge done it. There wasn't no technicality that dismissed that case. It was because I was innocent. The judge looked at it, listened at it, and it was totally dismissed. Me and the girl, we went to the prom together. We were engaged to get married. Till they just mysteriously told this man the suspect in the robbery, and I go to prison 12 years. She gonna get married. She gonna her life. So they need to know, hey, this man wasn't guilty of this. Because of their mind, they might think I was guilty. And it's misleading.
All right. I'm not going to be able to launch into that sort of information. You can, if you want to leave it alone, and you can address it yourself.
But John, I wish he would do it, but I wish you could have him do it. He the one open it up. But I doubt you're gonna do that, just like how you gave them instruction during the trial, I prefer you do what you did to them. It need to come from a professional standpoint, you know.
You want to be heard, Mr. Mullin?
Judge, again, you go under listed information about the, he represented on a matter in which he was acquitted. So I have to witness on cross, and I'd like to delve into that, once he elicited that, that's his witness. And, given that, in addition, the witness already indicated, he said, well, the judge threw it out. I'd like to, if Your Honor wishes to give a period of instruction, request, and that's fine, either one. Frankly, I think it was permitted cross-examination based on what he elicited himself during his own direct examination of his witness who happened to be an attorney.
Again, Your Honor, in my position, they need to know this man wasn't guilty of this because he wasn't guilty. And they might think he could be guilty. I seen how the one jury just looked at the lady with the glass. Somebody having her life, or somebody, her loved one life, she can hold that against me. So they need to know the man was not guilty of their charge.
And I'm only going to give them a period of instruction about disregarding testimony of that charge. You choose to approach it some other way.
I understand, but it's old saying, when you unring a bell, you cannot, when you ring a bell, you cannot ring it.
And I do believe that your witness
But it
brought it
wasn't
out.
me. But it wasn't me.
Well,
I'm here for me. I ain't here for
It was your witness.
But it wasn't me. How many times your witness said something, you gave us curative instruction, and the same thing?
And that's what I'm about to do.
So,
That's what I'm about to do.
yeah, you just can't have no one, John. They need to know the man wasn't guilty, because I have not been found guilty, never was guilty. They need to know Mr. Hood was not guilty. It ain't disregard. Mr. Hood was not guilty of that charge. And you can't disregard.
What was the charge?
It was a kidnapping rape charge, me and my high school girlfriend. Well, my fiance.
I just ask him a question. Kidnapping, rape
Exactly,
charge.
exactly.
What year?
What was that, 97? That was 97. 97, I think. I think it was 97. Matter of fact, Judge, I got our prom picture when we went to the prom after that and everything, so.
I don't see that.
He has those pictures, I'm not aware that we're given those, we'll have to look and see if we can give them.
Is it correct that the charges were dismissed? You dispute that?
I really don't know. I don't know that there was a
He go to the office,
conviction.
he got the GDC, but the judge, they were admitted, so he knows.
Mr. Hood, I'm just trying to figure out if they would what happened to them.
I'm not aware he had a conviction, Judge. I don't know the results, to be honest with you. He asked that question, that's why I was asking the question.
You know, all due respect, Mr. Mall been having a whole record for years. It's on the record here. I went to court, but one time, we went to a preliminary hearing, and it was gone.
Here's what,
I'm not disputing. You asked me, did I know? I didn't know.
That's fine.
I know he didn't have a conviction. I don't know the results or exactly what happened with the case.
here's what I'm gonna tell the jury. Jury will disregard testimony, related to a kidnapping rape charge in 1997. The charges were dismissed.
Yeah, but Mr. Martin said they didn't even say nothing about it.
Well, I thought that's what y'all said.
No, he said a rape.
Okay, I can start kidnapping. I don't know who said that. I
What,
thought you
this was
said
it.
that.
I mean, you asked me what the charge was in whole, but I didn't, it never came out.
So I'll believe kidnapping.
Yeah.
Could you read it one more time?
Sure. Jury will disregard testimony related to a rape charge in 1997. The charges were dismissed. I can leave out the charges were dismissed. Talk to him.
Not trying to interject myself.
Talk with him.
Okay, he said the charges were dismissed. That's the best you gonna get. The charges were dismissed.
Yes.
Just tell them, you know, the rape charge was dismissed by the judge. It was a, we let me here, we ain't go no further than that, they just dismissed the charges. As I say, I got a picture right here, we had the prom after that, you know. So that's what I take them kids to trust, we move on, I'm really get over with it.
You're asking that I add the language, the charges were dismissed by.
The judge.
Want to be heard, Mr. Small?
That's fine.
All right.
I mean, I think he opened the door with the question, to be honest with you.
But obviously, that's, we're gonna stay away from it going forward. All right, see if they can come back in. Ladies and gentlemen, you will disregard testimony related to the charge of rape in 1997. The charges were dismissed by the judge. That continues.
Smith, we were talking about the motion that you filed, the motion to suppress that you filed concerning identification. You did that pretrial, did you not?
I don't, if you have a document, I would like to look at it.
Let me show you 1440, it's already been shown to the defendant. That transcript that it was left impresses your memory.
I don't remember any of this. This was how many years ago? 18?
Have that back. Basically, you don't recall there being a hearing on December 5th, 1997, a couple weeks before trial, 10, 12 days before trial, before Judge Jones.
I do not.
Identification of motion expressed. You don't recall that?
I do not, I think I've answered, I do not recall that.
Okay. And,
I should have filed a motion, there should have been a hearing, I just don't recall it.
and let me show you what I've marked as state exhibits. $14.42. You recognize that as a copy of an amendment to a motion to suppress identification testimony that you filed.
Well,
You recognize that?
the document speaks for itself, I do not remember this.
You don't remember that at all?
I have no memory of 18 years ago, 17 years ago, whatever it is, of each minutia of this case. I got the broad strokes. I know exactly what I think he was incorrectly convicted.
Yes. And now let me show you what's been marked as state exhibits 1441. You recognize that as an order in the case where the judge denied the motion to suppress identification testimony?
I recognize that it is an order. It is in Mr. Hood's case. Other than that, I mean, it speaks for itself, obviously. You know, you're asking me to...
So basically, the various pages of the transcript from the trials we were able to review and just recognize out of different contexts there, but the orders in these matters or otherwise, you don't recall basically there being a hearing on that or anything like that?
You misquoted me. I did not look at that transcript and identify anything in that transcript. I did not say that.
I got it. Your Honor, we would tender state exhibit 1441 into evidence at this time.
Any objection?
No, sir, Your Honor.
Admitted.
And if you will, sir, please read the order that was signed and a copy to you in that matter in December of 1997. In this case,
After hearing evidence,
go ahead.
are you through?
Go ahead.
After hearing it says, order, after hearing evidence on the defendant's motion to suppress identification testimony, the court hereby denies the motion. In reaching this decision, the court relies on the test set forth in Neal versus Biggers, 409 U.S. 188, 93 Supreme Court, 375, 34, Large Edition, Second 401, 1972, and concludes that the show-up identification at the time of the defendant's arrest was not impermissibly suggestive. That a copy of this order be served upon all the parties as provided by law. So ordered this 5th day of December, 1997. Steve C. Jones, Judge, Western Circuit Superior Courts.
Yes, sir. And that's in favor, ma'am. And during the trial, you've indicated, of course, you indicated during the trial that the court made a motion for directed verdict that you went through and read here on direct examination. Is that correct, sir?
Yes, I read it.
Sure. And you read, of course, that you made a motion for directed verdict in challenging the identification that was testified to during that trial. Is that right?
That's what I read.
And the judge denied that, correct?
That's what I read.
Okay. Now, of course, you vigorously defended the defendant during that trial, did you not?
Not well enough. I made a mistake.
You vigorously defended him throughout that trial, didn't you?
I made a mistake, sir. I don't call that vigorously defending if you make a
Well, you
mistake.
indicated, of course, that at the start of this, you basically said that, at the beginning of your testimony, that he had to remind you of his case before you got on the stand, right?
Did what? I didn't say that.
You didn't say that the defendant had to remind you of his case and what happened during the trial? You didn't say
I
that on the
don't
stand?
remember saying that.
You don't remember saying that, okay? But you've indicated there, you don't remember all the different minutiae or anything like that.
Do you? 17 years ago? No, the answer is no.
Okay, thank you. Now, you recall basically the testimony of Officer McGee during the trial.
Sir, I told you, no. Who is McGee?
And you recall there being a written police report at all from Officer McGee,
There must have been,
okay?
if you say there was. I don't know. I don't remember.
You remember basically in that report, Officer McGee indicating that after the car was stopped,
Sir,
he
I told
noticed
you.
that, Your Honor, I have it.
I don't
Ask me my
remember
question.
I don't remember anything about it. I've told you that.
Your Honor, I'm asking the question. I would ask him to allow to answer.
Let him ask his question.
Okay. You don't remember him putting in his report, later testified, I noticed that the front passenger, Jamie Hood, kept bending forward and reaching around in the passenger side floorboard. You remember him taking that after the car was stopped?
Sir, I'm not surprised. The police frequently say that. I should read all kind of reports where someone was bending over, appeared to be hiding, blah, blah, blah. I see that all the time in police reports.
So you remember that or do not?
I told you I don't.
Okay. And do you remember basically after that the victim of the armed robbery, after he came up there, that the officer noted that Jamie Hood removed his white T-shirt and started putting on a red shirt? Do you remember that
Sir,
at all in this case?
You can read the report to the jury. I don't remember any of it. I've told you. What you're doing is reading the report. You might as well read it.
And so
Because I
you
don't
remember
remember.
basically
You know, he ought to be on his oath,
the
actually.
defendant was asked to put the white shirt back on. Do you remember that?
Your Honor, I don't remember any of this.
And I have a chance to, he basically indicated, on direct examination, indicated the things that he did remember and started talking about the things. In fact, he was asked on direct, tell us about what happened during the trial.
Ask
Thank you. Thank you.
I
Do
remember.
you remember the,
Hold on, I want to answer, I want to respond to your.
Your Honor, he's already.
You did
responded.
ask me.
I asked him to, let me ask you a question.
He can finish his response.
I told you I remember the broad strokes, not the minutia.
You remember basically, the defendant wound up telling the officer after he wound up saying that, saying, white shirt, red shirt, it don't matter. You remember that? Coming out during the trial and in that police report, do you remember that?
Is that what you're testifying? I don't remember.
Okay.
Is that your testimony, Mr.
You
Moore?
remember that there was money spread on the passenger side of the floorboard where the defendant was? Do you remember that?
Mr.
Including
Malden.
$3 $1 bills, do you remember that?
Mr. Malden, I don't remember any of that
Okay.
report. You
Okay.
have not furnished it to me prior to this trial to review.
And you remember that basically when he was placed under arrest, that he blurted out, you didn't find no gun, you ain't got nothing? You remember him saying that at all, or that being testified to, or brought up in the police court or otherwise? You don't remember that either?
I don't remember that.
Okay.
Did the pizza driver say there was a gun? Was there a gun found? I don't know.
You remember that the handgun was located concealed under the dash on the passenger side of the center console? You remember that?
Mr.
At
Malden,
that point, you recall that? Yes or no, sir?
if you're testifying,
Your Honor,
I
I'd ask
cannot
him to answer
refute,
the question.
Mr. Malden, I cannot refute your
Your
testimony.
Honor, I would ask him to please answer the question. If he wants to explain his answer, he can. I would ask him to answer the question, yes or no, and then basically walk him through the
I'll
response.
ask the witness to answer the question, and he may explain his answer.
I'll check ask and answer. He already answered. He might not like his answer, but he already asked and answered. You keep beating it in the ground, but if you want to sustain it, that's, you know, that's your position.
He didn't answer his question, yes or no, he just.
I-
Let me re-ask the question, Mr. Smith. You remember the handgun was located concealed under the dash on the passenger side of the center console? Remember that, sir?
Yes, Mr. Malden.
I'd ask
I've
you
said
to
I don't
answer
remember.
that question.
Mr. Malden, no, I don't. Answer no, I don't, and I want to explain.
Go ahead.
I have told you, you're reading a document, it's not in evidence, it's not a witness's testimony, and if you're testifying, then you ought to be on the road. I don't remember any of that.
And you remember basically after the defendant was read Miranda, he replied, yeah, when asked if you understood.
Mr.
He
Malden.
stated, I listened to you, now you're going to listen to me.
Mr.
You didn't
Baldwin, I'm
find-
going to ask that you mark that, let the witness look at the entire report and see if he remembers any of it.
Your Honor,
Please.
that was my last question about the report. I'm testing his memory about it.
Was that your last question?
That was going to be my last question about the report, if I may. Thank you. You remember basically after the defendant was read Miranda, you replied, yeah, when asked if you understood, and then stated, I listened to you, now you're going to listen to me. You didn't find me at no scene, you ain't got, excuse me, Your Honor, shit on me. You remember that being in the report and testified to it all during the trial by Officer McGee? Do you remember that at all?
Same answer as the previous.
Okay, thank you. Now, you indicated, of course, that you was granted a new trial because you should have filed an alibi. Is that correct, sir?
I should have filed a written notice of alibi in spite of the fact that the DA and I had talked about it. I remember so vividly. You know, like I remember when the shuttle blew up. I remember when Kennedy was assassinated. I remember so vividly right out here in the front of this courthouse talking about the alibi about a week and a half before the trial because I was so shocked when Danny Love got up and made the motion to exclude it because I hadn't put it in writing. And he knew exactly who the witnesses were. I can vividly remember right out here in front of these newspaper boxes having that discussion. And I was shocked and flabbergasted and embarrassed because I hadn't put it in writing. And I was shocked that the judge upheld it. Today it would not have been upheld. Today the law is different.
You recall testifying at the motion new trial in that matter filed by the public defender, Tom Killeen?
No, sir, I don't.
You don't remember that? Let me show you which is marked in State District 1443. You recognize that as a transcript, recorded transcript of the motion of new trial in the case?
No, sir, I don't recognize it. I've never seen it. I don't know anything about it.
You don't recognize that at all?
No, of course not.
Okay?
I've never seen it.
Even though you were able to just recognize and recall certain pages of the trial transcript that were shown to you really somewhat out of context, but somehow when you have a complete transcript of the motion of new trial, you cannot
I would object to that because he went to did for almost a month, they can't recall it.
That's not an appropriate objection.
But it's the truth. He went and did the same thing he doing what he crying about.
So, sir, if I can, Senator, I would this time tender page 6 of the transcript in State Exhibit 1443, which is the transcript from the motion of new trial, which Jim Smith testified at that time. I would tender that into evidence at this point. And it would be, I guess, maybe 1443A would be the best way to label that if that's the best way to report.
One single page?
At this point, yes, sir.
Let Mr. Lee look at that, please.
I don't need to see see it. I don't need to see it.
I would tender that into evidence.
Any objection?
Other than what Mr. Smith said, he don't see it, I don't have no objection, y'all.
Submitted without objection.
And probably ought to, I guess, Judge, the first page, the cover page of 1443, as well as page 3 that indicates Jim Smith's testimony. I will offer page 3 as State Exhibit 1443B, and then the cover page of the transcript would be 1443C. Even though I've already marked the whole transcript of 1443, we'll make a separate copy.
Any objection?
Well, yeah, I think the transcript speak for itself, it's in there. So we don't need to introduce all that, it's already in there, he can just pull it out.
Transcript has not been admitted.
It's duplicative, Judge, because it's the same thing over and over, that'd be too long. But you do it how you want to do it.
Well, the transcript has not been admitted.
Okay. I thought he admitted it.
No, sir.
Okay, well, I apologize, I thought he admitted it.
It was identified.
Okay, okay, well, I stand for it.
So there's no objection to
No, sir.
1443,
No, sir.
B, C,
No.
and A?
No,
Yes,
sir.
Judge.
All right, they're admitted.
All right, let me show you this, if I may, Judge, on the screen. Thank you. See that is 1443C at the bottom, sir, purporting to be the transcript of the motion for new trial in case number SU 97 CR 0877 with Mr. Tom Clean, the attorney at law at Legal Aid Defense Society. Is that correct, sir?
You
Smith?
talking to me?
Yes, sir.
I thought you were talking to this court. I mean, I can read the English like you can, sir.
Yes, sir. And that was reportedly held June 22nd, 1998. Is that correct, sir?
I don't know. The document shows that, if that's what
Okay.
you're saying.
Thank you. And State's Exhibit 1443, page 3 of that transcript, shows that you were called as a witness in that matter by Mr. Colleen on direct examination. Is that correct? Indicating that you were an attorney. Is that correct, sir?
It looks like it's referring to me.
You don't recall testifying in both new trials?
No, sir.
I see, okay. And 1443A, sir, you recall basically in that there's a question there from Mr. Colleen starting at line 5 and your answer starting at line 7. Would you please read that question to the jury first of all on lines 5 and 6?
Question, do you know why? Could you tell us, you can read better than I. I'm not a very good reader.
Well,
Or the jury can read it.
I'm not ask the witness to read. He didn't have any trouble reading.
I don't have any trouble reading, Mr. Baldwin. I'm not a good reader, I said.
Would you please read those lines, please, sir?
Do you know why? Could you tell us why you did not file a motion of an intention to present an alibi defense?
Yes.
Line 7, answer, yeah, there's several reasons. One is I really didn't think of it as alibi. I just thought of it when the state is going to use a witness and I can prove by that witness my client is not guilty. I don't think that's me, a burden on me to do something. Another, you know what a real practical reason is. I can tell you what a real practical reason is. My poor client was sitting out there in jail. Normally, I depend on clients to come into my office 2 weeks before trial and we'd go over things that need to be done and I do them. My poor client was sitting in jail. He couldn't come out and see me. And so that's another reason. That's a very practical reason that if it needed to be done, it wasn't done. But there's real theoretical reason. I didn't, in my mind, the DA, I mean, it was an alibi in the sense that it was him saying he couldn't have been there. But in my mind, the DA has the evidence. I was simply following up with the evidence.
Go ahead and read
The
23,
court.
24, and 25.
The court, so you thought the DA was going to call those witnesses and you would cross them? Answer, yes, sir, I really did. I really thought he was, because I'd given them the witnesses.
Okay? And, Judge, let me go ahead and
J-
introduce
j-
page 7.
And I'd like to
which is
further,
page
I need to
14,
explain, Judge, I need to explain the
which
witness
is
my answer.
page,
Uh,
14.
Okay, and Ms. Malden, it was furthermore, it was like the witness at the end.
That wasn't responsive to the question of him simply reading something.
I'm gonna allow him.
It was,
D, I mean, excuse me.
it was also like the witness at the front desk at the hotel. You all did call, the DA did call that witness, and I thought the DA would call the others. Probably, since I'd given them.
I would tender 1443D, which is page 7, which follows up with that answer there.
Any objection?
No, sir, no.
Submitted.
So at the bottom of 1443, you're being asked by the court, so you thought the DA was going to call those witnesses and you would cross-examine them. You said, yes, sir, I really did. I really thought he was. 1443D, go ahead and read from line 1 the rest of your answer to that question by the court.
Call those witnesses, especially the girlfriend. I thought he was going to call her and make me look like an idiot. And I went and talked to her, and she was going to be on my side, but I was sandbagging him, I thought. And it ended up, I was the one that got sandbagged by the DA because I didn't do the motion to introduce the alibi, the court. But in your strategy, you preferred cross-examinating those people rather than direct. Answer, yes, sir. Question of the court. Go ahead, Mr. McLean. Answer, yes, sir. And I think it would have been if he had called the witness, I mean, clearly I would have had a right on cross-examination through a thorough and sifting cross-examination. Court, exactly. Answer, which would?
Now, so basically, after looking at all that, it's, you were making a decision at that time that you thought the DA was going to call those witnesses. So really, you thought it'd be better to try to cross-examine them. Isn't that correct, sir?
No.
Isn't that what you testified to here during the motion of new trial, sir?
That's part of what I testified to.
All right. And,
But that's, I don't answer me. I don't explain the answer. No, that is not the only thing. I made a mistake in not filing the notice. I called it a motion in that testimony. I made a mistake in not filing the notice, even though, as I said in that testimony, the DA and I had been talking about it for 2 weeks. It was not a surprise.
you also indicated that you were going to try to sandbag the DA, did you not, sir?
The same way he did me, I guess. No, I was just not telling him what I had, my work product was not revealed to the DA.
You preferred to cross-examine them, right?
My work product, I preferred to keep to my vest.
Yes.
And I prefer to cross-examine witnesses if I have evidence that would contradict the state's case. I didn't finish my answer, Mr. Malden. I prefer to keep evidence close to my vest and cross-examine witnesses if I know it will contradict the state's case.
And so that was your strategy at the time, sir?
My strategy was no strategy at all. I just forgot to file the notice.
Yes.
That's not anything strategic at all.
At the beginning of that, you indicated you didn't really think of it as an alibi, right?
Sustained.
Now, sir, you've indicated before on direct examination, when you were describing the events here, you indicated that the victim, you said this at least twice, that the victim was brought to that location by the police. Isn't that what you testified to on direct?
He got out of his car, walked over there, and they brought him and to look at the, yes, sir, that's exactly what happened.
You gave the impression that the police brought him to that location where the car was, right?
Well, they had to be in touch with him somewhere. He stopped, they brought him then to look at the guys. That's what I said, and that's what exactly happened.
That's not what the testimony was that you read over here before, where you testified the victim had testified that he was driving by and just stopped, right?
Because there
Is
were
that
a lot.
what you read before?
I did, but that's not,
Okay.
but they brought him from his car to a position where he could look and identify the short man, the short, dark, black guy, the short guy, who didn't look like he does today.
Yes. And as you indicated, there was a trial again after this, in which the defendant was represented by the public defender, as you recall, right?
I do recall that there was a trial, and I think I told you I don't know, I think the public defender represented him.
When you indicated that at that time, the alibi was certainly available at that point, correct?
I don't know, sir.
Well, did you testify on direct that it was, that everybody knew about it? Didn't you say that?
I said everybody knew about it way before the first trial, sir. I just told you that.
And at that time, of course, he was convicted by a second jury at that time, right?
I don't know. He's got a conviction. I would assume he was convicted, wouldn't you? I do know he was convicted.
Yes. Thank you.
We're ready. Brief. Your Honor, I would like Mr. Smith to look at the exhibit, what we at 93, what would be at 93? 94, we'll be going to 94. Exhibit 94, page 255, Your Honor. Mr. Smith.
Before you show it, are you gonna tender
Yeah,
that?
yeah, I'm sorry. Mr. Smith, do you recognize what you just viewed in the exhibit 94, sir?
I saw the transcript.
Okay, you saw it. Is that a fair representation of what you said at the trial, off your recollection?
I really don't recall that, but I'm sure
Or
it's,
is it possible that you was there, is this what you, sir?
if the transcript says I was there, obviously.
I move to tender, defendant exhibit 94. Yeah.
Okay.
Mr. Smith, I'd like for you to read from line 11. Well, I guess you can just read from line 11 to 25. We'll go from 11. Can you please read that, sir? Start at line 11.
It says, do you have a tape? I was asking, it looks like I don't know. I would assume I'm asking a police officer.
Oh, yeah.
Do you have a tape recorder? Answer, no, sir. Question, video camera? Answer, no, sir. Question, so you only wrote down what you felt like would help you prosecute my client, right? Answer, no, sir, I wrote down what he said. That's all.
Okay. Now, Mr. Smith, could you tell us why the Athens Clark County Police Department never represent no audio or video of police call concerning me and my group?
Well, that's argumentative and certainly speculation, not science.
Mr. Smith,
You want to be heard on the objection?
I was wrong. You did ask him, did he have audio or video tape recorded, did you?
Yes,
Okay. Is it normal for the police car to have audio or video cameras on?
yes.
Could you tell us why? Well, why do you think when the thing is that good, audio or video camera always disappear?
No, that's pure speculation and it's argument.
Did they offer you any audio or video camera when you asked for it?
No.
Would that be deja vu all over again?
No, that's pure argument.
Sustained.
No further question, Your Honor, Mr. Smith.
Anything else, Mr. Palmer?
No, Your Honor.
Any excuse?
Yes.
Yes, Your Honor.
Your excuse, sir.
Thank you.
Call your next witness.
I know you ain't gonna like it. but it's only a team.
Okay. 5 minute recess.